I was sanitizing.
Yeah, I see that. Okay. All right, let's do this. Let's do this podcast now.
Okay.
Hello and welcome to Learning the Law, a podcast about all things legal with a focus on current events, where we try to teach you things in an hour. My name is Ashley, aka Phoenix Nymphy, and my co-host, who is the man of the hour, my husband, Ron, who is also trying to sanitize himself. The podcast is purely educational and should not be taken as legal advice. This podcast does not create an attorney-client relationship, and this podcast is based on his interpretation of relevant law. Any opinions expressed are the opinions of individuals making them and do not reflect the opinions of any firm, company, or other individuals. Ron is a licensed practicing attorney in the state of California.
Yes, I am. And I have been since September 15th of 1999.
So, what we have today is we tried to do live, but my computer is being a butt. I don't know what's going on. But when I'm in Discord and I'm trying to stream, for some reason it decides to make everything quit. So this week we are actually talking about this topic. We are actually recording and then posting it. So we do apologize for this not being live, but if any of you have any questions about this particular thing and we don't address them on the podcast, please feel free to send us your questions. I know that this particular case that we are discussing today is very personal to a lot of our friends. We are discussing the Activision Blizzard lawsuit today because, well, we're both gamers ourselves, and we met in WoW. So Blizzard, has a huge, World of Warcraft has a huge, is really important to us because it is where we met. It's how we dated, and it's just really personal to us. I will caveat that we will be touching on very sensitive subjects. So this is your warning. If you feel that we're going to be talking on subjects of sexual assault, sexual harassment, suicide, and several other things in this particular podcast. So be warned going into it. I just want to be respectful to those people who it could possibly trigger some, many things. So please keep that in mind listening to this week's podcast. So if you're listening to it, all of the links to everything that we discuss will be on the website under the podcast notes. If you're watching it on YouTube, I've put it up on the screen so that you can follow along with what we are talking about, because it is 29 pages of this document. It is very serious. The state of California Department of Fair Employment and Housing has filed a lawsuit against Activision Blizzard. And trying to think, is there anything else just to kind of... I think that's about it. I think that
covers it.
Covers it all. So what we're going to do today is we're going to have Ron kind of go through this and explain to us piece by piece, because we talked about it on TikTok. I've talked about it on Twitter, been discussing it, all week. We went on vacation last weekend, so we didn't make TikToks going in depth about this because we were on vacation. However, we did have a few people show interest in wanting us to break down the pages and break it down and really go in depth. And that is why we are here today discussing this. We will be back next week with our mini series on the First Amendment.
Yes.
But first things first, as a woman in gaming, this is not news. This isn't new. I myself actually advocate for women in gaming, women in the entertainment business. And so this is something that actually is very important to me. It is one of the things that I work on through girl streamers or women of gaming. This is what a lot of these communities that I'm a part of go into. A lot of like all of my friends, like if you watch our streams, like we are constantly talking about the subject matter that has come up in this particular thing. So this is not a new thing, and it's not exclusive to Activision Blizzard either. It is across the board in the gaming industry as a whole, because the gaming industry has always been treated like a boys' club, and women have always been pushed aside. And for the purposes of this case, we're going to use the binary speech. But when we say women, please know that we're talking about all women. If you identify as female, that's who we are talking about. This is all women. It's not, just male, female. It's all people who identify as women. And the men that we're talking about are cis white men. I just want that to be clarified in our phrasing as we discuss this. So first things first, the first page is basically just the introduction and talking about all of that. You want to kind of explain what this page is?
Yes, because if anyone gets served with a complaint themselves, they'll want to know what the sections are. Top left section of the first page. This is the place where plaintiff's counsel puts their contact information and who they're representing. As you can see here, there's a chief counsel, an assistant chief counsel, and an associate chief counsel, and they're the attorneys for the plaintiff, the Department of Fair Employment and Housing, which is an agency of the state of California. In the upper left corner, you see the day when it was filed.
You mean the upper right? That is the right side of the document, babe.
Yeah. I have a tendency to do that. And the top right, where it says filed, you'll see that it was filed July 20th, 2021, and it's signed by the deputy of the court. So if you go down, you will see on the left side, there's line numbers. I'll be referring to those throughout this podcast. And you'll see on line 8, it's in the Superior Court of the state of California in LA County.
Mm-hmm.
As you go down, on the left side, on lines 10 through 16, it'll show you the parties, who's involved. The plaintiff is the person who initiates the lawsuit. And as you can see, it's the Department of Fair Employment and Housing. The defendants, as you can see, are Activision Blizzard, Blizzard Entertainment, and Activision Publishing, plus does 1 to 10. And what a doe is an unnamed defendant that through the course of the litigation, if someone else needs to be brought into the lawsuit and sued, they would replace one of the does.
What does inclusive mean?
That just means in its entirety.
Oh, okay. Okay. So I do have a question. Why is this brought by the state of California and not a class action? Because it does feel like the kind of content that's there could be a class action lawsuit.
Right. The reason it's not a class action is because it's the state that's doing the suing. And so the state will be the one that receives any kind of damages. and the state is the one that can enforce any kind of injunctive relief and make them equal pay.
So what about the women who have suffered damages? Will they receive any compensation out of this if it's the state of California that's suing them?
The women would receive compensation if there are money damages.
For example, we'll talk about this later, but one of the things that they're bringing up is the fact that, the wage difference between men and women is very large. I mean,
Right.
could they not get compensated for that gap, for that money that?
Yeah, they could. However, if there's any kind of fine brought by the state gets fine money.
Okay.
If there needs to be some civil rights enforced, the state has to do that. If the women brought their lawsuits individually, they could get money damages.
Now, could the women still do that and attach it to this particular lawsuit?
It's going to depend on the kind of judgment that comes out of the court.
Okay. So it would have to happen after this lawsuit is done for the women
Yes.
to. Okay. So this lawsuit is the state of California going, whoa, you have really broken our laws. This is not okay. This has to be fixed.
Right.
Okay.
Now, if there's no compensatory damages, the women could still bring a lawsuit.
Mm-hmm.
But if there are compensatory damages, and money is distributed to the women, then that would be the end of it.
Now they had the opportunity to settle and they did not. They chose not to settle.
Right. This went to mediation before this lawsuit was filed.
So they knew this was coming. Activision Blizzard knew this was coming. Why did they not settle? Like, what was?
I don't know. This surprises the hell of me that they didn't.
Right.
Usually by the time the state of California steps into an investigation in a case like this, they got a pretty solid case. And they should, the attorneys for Blizzard should know that they have a solid case.
Right.
In addition, the bad publicity, this is going to drag on for a long time in the courts.
Yeah.
And it's going to cause their stock to plummet, which it's already starting to. So I don't know why they didn't settle. If this had settled in mediation, I doubt that this would have gotten the publicity that it has.
Honestly, I'm kind of thankful that it did, even though I play Blizzard games. Overwatch is one of my favorite games. You still play WoW. I'll occasionally hop into WoW and play with you. Even if it shuts down these games that I love, I'm glad that it's been brought forward because this isn't exclusive to Blizzard. This isn't exclusive to Activision, and it needs to be public. It needs to be handled, and we need to move forward with this. So legally, I don't know why they didn't. I find that weird that they didn't as well, because I feel like in the long run, it would have been cheaper for them to just settle. However, they didn't. So we're here now. And I
have one other statement on that because it just hit me. Ian Hostakosis, who's, the head honcho over at Blizzard, he's an attorney.
He is an attorney.
He should have known better himself to settle. Not regarding what his corporate attorneys are saying to him. he's a smart enough guy in and of himself to know what's going to happen.
Right. Well, and I wonder if maybe I don't know, maybe it wasn't bad advice, but maybe it was a situation of somebody said, no, I want this to happen because it needs to, like, and I'm not saying he would have done this, but maybe, maybe there was a good guy. Basically, I'm alluding to maybe there was a good person, a good guy who said, no, let's just let it out because that's the only way that it's going to change. You know what I mean? Sometimes people are like, this is the only way to fix the problem. I'm just going to kind of let it happen.
I can see that that's a possibility. But in my experience during my life, those people are rare.
Right. Yeah.
And they usually don't get into decision-making positions.
I also think it's telling that you have, in the last 2 years, all of the old Blizzard heads have left except for Ian Hazakostas. So
at the end,
they
remind
knew
me
it was
if
coming.
you can. Okay, this will be my opinion. Okay.
Do you want to tell your opinion at the end of the podcast?
Yeah. I'd rather go through the complaint than tell my opinion. But just
yes, I'll write it down.
Make a note that I want to address why people left, in my opinion.
Okay.
Okay. So here we are. We're still on the first page. In the middle, lines 10 through 16. That's what's called the cap. Basically it's the caption. It's got the case number. Anyone can Google that and bring this up. And it tells you what you're being sued for, or what Blizzard's being sued for. And it's a Civil Rights and Equal Pay Act for injunctive and monetary relief and damages. The injunctive relief will be, civil rights orders, and the monetary damages would be fines and compensatory monies.
What's compensatory?
Well, that would be a fund that the women that had complaints
that goes to the victims. Okay.
Yeah.
Okay. And then it says jury trial demanded.
Yeah, they want a jury trial. They don't want some judge.
No, I totally get why.
This.
In this particular case, I get why you want a jury, because this is a perfect case to take to a jury, because you want to kind of work the emotional angle.
Yeah, you want people pissed off.
Yeah, absolutely. I would also ask for a jury trial if I were, the plaintiff.
Now, it could be that Activision Blizzard also wants a jury trial. In the end, I would be surprised at that too.
Right. Okay. So moving on.
The bottom half, or lines 18 on the first page, that just tells you what code sections that they're suing under. You can Google those and read them yourself. They're going to be, all legalese, but basically, it's sexual discrimination and fair pay and sex harassment. And we'll get into the actual causes of action later in the complaint. So as you scroll down, get on page 2, there's an introduction, and it goes into how sexism has plagued the gaming industry for decades. Women now make up 50% of the gamers in America, but the industry caters to the men.
Mm-hmm.
Tells that Blizzard, double-digit percentage growth, 10-figure annual revenue. And what that means is tens of millions.
Yeah.
I'm
And
surprised it's only tens of millions. I would have thought that it was hundreds of millions. At its peak, I know Warcraft brought in over $1 billion a year.
yeah.
So, and if you will see on the end of line 8 through 9, it says defendants' compliance with California's broad workplace protections is long overdue. Now, as you're listening to this, please remember that California has a lot of protections for its workers that a lot of other states in the U.S. do not. So while this lawsuit could be brought in California, if it was brought in another state, there may not be these protections, and it may fail.
Right.
As you go down, it goes into the history of Blizzard somewhat, where they're headquartered, how many employees they have, what kind of games, that they're a member of the Fortune 500. It continues on to the third page, where you also see that Activision Blizzard has three major subsidiaries: Blizzard Entertainment, who's being sued, Activision Publishing, who's being sued, and King Digital Entertainment, who is not being sued.
It is not named currently in this lawsuit.
If during the litigation process evidence comes out that King Digital also was involved in these harassment and unequal pay allegations, then they can be brought into the lawsuit and replaced by one of the does that was on the first page. So like Doe 1 could become King Digital, for example. And every complaint has this kind of introduction. So the judge gets familiar with who all is involved. That's the purpose of the introduction. Because let's face it, a lot of judges are out of touch with modern culture.
Yeah.
So it goes in and says, they do the Overwatch League, Call of Duty, Blizzard does Warcraft and Diablo and Overwatch. And then line 7 on page 3, defendants' workforce is only about 20% women, which does not reflect modern workforce, especially in the IT community.
Nor does it reflect the people who play their game.
Correct.
Or games.
It goes on to say that its top leadership is also exclusively male and white. The CEO and president roles are now and have always been held by white men. And very few women ever reach top roles at the company. When they do reach the higher roles, they earn less salary, less incentive pay, and less total compensation than their male peers. And this is important on line 11, as evidenced in defendants' own records.
I think that's really important that that right there, like, the state of California really is not playing games when it comes to this. Like, they're using their own words, their own crap against them.
Yeah. And one of the things that the defendant should have gone off in their head was, oh crap, they're using all of our payroll records against us. Maybe we should settle, but they didn't. And as you go down on page 3, you will see a table on lines 18 through 28 where it shows an example of the compensation that some of the executive officers in the company got. And as you can see, the men received a great deal more than the woman that is shown here.
You want to go over? You want to kind of talk about some of those numbers?
Yeah, the CEO, Robert Kotick, in 2020 made about $1.5 million, and he got a total compensation package of almost $155 million.
That's insane.
Most of that, of that $155 million, is he cashed in some stock options.
Right.
And he probably knew this was coming, cashed them all in, because that stock's going to plummet.
Oh, I didn't even think about that. Oh, yeah, that makes sense why that number's so big. That's messed up.
That goes to some of my opinions at the end of this lawsuit.
That's so messed up.
At the end of this podcast. Dennis Durkin, almost made $1 million, $13 million, basically, in compensation.
Yeah.
You got the chief operating officer getting $1 million and almost $13 million in compensation. Then you have Claudine Naughton, the chief people officer, getting 2/3 of $1 million and just under $4 million compensation.
She made $250,000 in 2019.
Yes. And then a little over $4 million in compensation. Whereas in 2019, you got the CEO getting $30 million in compensation. You got the former chief financial officer getting almost, $9.5 million in compensation.
I mean, don't get me wrong, $250,000 is nothing to snub at. However, when you compare that, she is an officer, a CO, a CO. She is a chief officer, just like the rest of these guys, and she is not making nearly the same amount they are.
Right. And I will tell you right now that the defense is going to be, she doesn't do what the CEO does or what the chief financial officer does. Doesn't matter. She's a chief officer.
Right. Right.
A chief officer should be paid equal, at least within a few percentage points of each other, not 2/3.
Right. Right. So moving on to page 4, is when they start getting into more detail.
Yes. Where it says, line 2, like the executive ranks, women across the company are assigned to lower paid and lower opportunity levels, and they start at a lower pay for substantially similar work. So if you got a male coder, for example, and I'm just going to throw numbers out, all the male coders start at $100K. You got the women coders starting at 60.
And if you have the same job, right?
Yeah.
You have the same job. You're both coders. They should all start at the same level. They should all start making the same amount of money. There's no excuse. There is no excuse for that behavior other than you don't want women to work for you. That's it. That's the only reason.
Here's the thing. Line 4, substantially similar work. It does not have to be exactly similar work.
If you look at an industry, you're going to have, so here's the thing when it comes, for you, for example, your starting pay, you had a pay range, right? Like everybody has a pay range when they go into a business, a corporation. Like there's a pay range of what these people should be making versus these people should be making. And I didn't learn that until way later in life. And I was a freaking department head for, a big box retail store. And I was only getting paid $12 an hour as a freaking manager. And I was so stupid not to ask for more. I was also 21 years old at the time, but I was dumb not to ask for more because I was doing a ton of work and not being compensated fairly when everybody else all the other people that were doing a department head job with significantly smaller departments than me were making a lot more money than I was making because I was young, a girl, and stupid. It's across the board for women when it comes to this. And this was working at a retail store. This was not working within a company like Blizzard. So this is not I will say this throughout the whole podcast, this is not new. This is how women are treated across the board in working environments.
Right. In line 4, you see that defendants promote women more slowly and terminate them more quickly than their male counterparts. And I am sure that they're using the defendant's own payroll and employee records.
Well, that's not difficult to look at either. Like, all you have to do is just look at the employee records to see, okay, why are these these ladies only worked for 90 days versus these dudes who worked for,
right,
2 years, right? Like, I mean, this is easy information to find.
Well, easy for the state. Wouldn't be as easy for you or me.
You know what I mean? Like this is information that when you're doing an investigation, they can't hide this. This is information they cannot hide.
Right. So here you on line 7, the start of the 5th paragraph.
Actually, you're missing something that I think is really important. Faced with such adverse terms, on line 5, it says, faced with such adverse terms and conditions of employment, many women have been forced to leave the company. Which basically means they were in such a hostile work environment, they were forced to leave.
It's called constructive termination. Yep.
What do you mean constructive? How do you mean constructive termination?
That's just the legal term for it.
Okay. So
they were made to leave because of the conditions.
So basically, like what you went through with your last job. Yeah. The conditions were so bad it forced you to leave.
Yes.
Okay. So we're still on page 4, line 7 now.
Right. Where it says, the defendants have also fostered a pervasive frat boy workplace culture that continues to thrive.
I find this fascinating that in a legal document, a legally binding document from the state of California, they're using frat boy as their term. You know what that says to me? In general, that fraternities have a specific stereotype and should stop existing.
This is another reason they didn't want to judge, because most judges come from
fraternities,
higher private universities, and more than likely were part of a fraternity.
This is my opinion. Solely my opinion. The fraternities,
that was my opinion. Yeah.
Well, fraternities and sororities need to stop existing because it creates this elitist attitude that people take through their life. And I say this as someone who has friends who were in sororities, and I gave them crap for being in sororities. Ask my friends. I gave them so much crap for being in sororities. I'm like, really? because that says so much. That just says so much to me when they use that term, frat boy workplace culture. There is a culture that is rampant.
Right, but the key word in that line is fostered.
Yeah.
They have got to have some evidence that, this frat boy culture was not just something that was passive. It was active.
Right. Well, I mean, if you continue reading, it says in the office, women are subjected to cube crawls in which male employees drink copious amounts of alcohol as they crawl their way through various cubicles in the office and often engage in inappropriate behavior towards female employees. They did pub crawls in the office. Pub crawls. They would get drunk at work. One,
yes.
Why are you drinking at work? First. Second, why are you drinking to the point you're getting intoxicated at work? Third, why are you treating it like a club, like a bar, and then going around and fooling around with so much? Such a massive part of me is trying not to use the these are men who never got to touch a titty growing up, and now that they're adults, okay, I'm trying not to go there, but that's what it feels like. That's what it feels like. These are big nerds because I can't, I gotta shut up.
Yeah.
There is a stereotype for nerds that they do this, and this is doing nothing but perpetuating that.
Okay. I don't know what you want me to say of that. I wasn't in a fraternity, so.
No. So what I'm saying is there is that stereotype, in any internet culture, but there's that it's the stereotype that nerds are the creepy, they're the ones who always are inappropriate and go too far because they don't know how to handle being around a woman. That stereotype.
Yeah, I know.
That's what this feels like to me. And they're just perpetuating a negative stereotype. And it's really hard for me not to say that's what they are. They're just a bunch of boys.
Okay.
But I don't want to do that because not all nerds are like that.
So as you can see, they give examples of male employees coming into work hungover, playing video games, while making the female employees do their work. Engaging in banter about their sexual encounters, talking openly about female bodies, and joking about rape. Now, I'm sure this came from interviews with current and former female employees. I don't know that it came from any interviews with male employees. I would hope that some of them would have copped to what was going on, but I'm also sure it comes from complaints made to the HR department.
Yeah. And
that were documented.
One thing that needs to be noted, HR is not there for the employees. HR
never
exists for the company.
Yeah.
HR is not your friend, and it never will be.
If HR can protect the company while it also helps out the employee, generally they do. But in the end, it's there to protect the corporation.
Yeah. So never, yes, make the complaints to HR because they have to file it. They have to put those files in there. But I was a victim of a boss who was inappropriate with me at work, and HR never did anything. So I learned the hard way that HR does not help the employees. It never will. This is
right.
I need to calm down because this is bringing up a lot of.
I know.
Can tell,
it's not going to get any better for you.
I know. As you can tell, this is very, very close to home. This is why we gave the trigger warning at the beginning of the podcast. So, like, I'm dealing with PTSD from this as well. So this is very this is very close to home for me. And brings back a lot of old memories. So to all of the people who have dealt with this for so long, I am so sorry. And I really hope that we get justice for you because this is not right. And I hope that this changes the gaming industry as a whole. I can only be positive. I want things to be better.
Paragraph 6 starts on line 14. And goes on to state that the frat boy culture, is the breeding ground for harassment and discrimination against women.
Mm-hmm.
They were subject to constant sexual harassment, including having to fend off unwanted sexual comments and advances by their male coworkers and supervisors, and being groped during the cube crawls and other company events. High-ranking executives and creators engaged in blatant sexual harassment without repercussions, and in a particularly tragic example, a female employee committed suicide during a business trip with a male superior who had brought butt plugs and lubricant with him on the trip. We'll get into that a little later on how they knew that.
I want to the next line is defendants continuously condone the quid pro quo and hostile work environment. And the message is not lost on their employees.
Right.
You sleep with me, you'll keep your job is basically what they're saying. And the fact
that's part of what they're saying. They're also saying that, if you go around groping people, we're not going to do anything to you.
Right.
Doesn't have to be tied to keeping your job or to pay. We're going to let the guys do whatever the hell they want to do.
A woman committed suicide during a business trip because of this behavior.
Yep.
And nothing was ever done to that person.
Correct.
I need people to understand that. And how messed up that is. And the fact that this person never lost their job, but a woman lost her life. Lost her life because of this. And she's not alone. She's just the only one in this particular lawsuit that you know of. Now, why did they know that the supervisor brought butt plugs and lubricant with him on the trip?
Because the police did an investigation, and when they interviewed this supervisor, they found it in his luggage.
Now, my question is, why didn't the cops arrest him?
On what charge?
I guess, do you know, did they know for a fact that it was a suicide? There's so much
it doesn't get into that.
Well, I know. It just, that whole, I feel like that guy should have at least lost his job. And he didn't.
I'm not going to disagree with you.
He's responsible for her death.
Well, we'll get into that a little bit more too.
Now we're on page 5 at section 7, or
yeah, section 7,
which is line 3.
Yeah, line 3. It goes on and says there's numerous complaints about unlawful harassment, discrimination, retaliation, and that it was made to the human resources personnel and executives, including, and this is the first named person in the complaint, Blizzard Entertainment's president, J. Allen Brack. And he's the one that put out a statement.
He put out a statement?
He did put out a statement. And when you read what's gone on, the statement is just a bunch of bullshit. My opinion. Defendants failed to take effective remedial measures. Employees were further discouraged from complaining because the HR people were known to be close to the people that were harassing everybody. Well, everybody, all the women. And an internal investigation, which is Blizzard's own investigation into the HR unit, noted there is a big lack of trust and that HR was not held in high regard.
Well, why didn't they do something about it then?
Because they didn't care.
Exactly.
And unsurprisingly, the employee complaints were treated in a perfunctory and dismissive manner and not kept confidential. So if you made a complaint against somebody, apparently that person would know who made a complaint. And there retaliation.
It's saying in this there was retaliation, including but not limited to being deprived of work on projects, unwillingly transferred to different units, and selected for layoffs.
Yeah.
Holy cow. Jesus Christ, man.
And here you have then in paragraph 8, starts on line 13. It tells you why the DFEH is bringing the enforcement action.
They seek relief in the public interest for the state and for defendants' female employees of the group.
Right. The group. So when you see that in a complaint, when they put something like that in quotes, from then on, the group means defendants' female employees. They just don't want to type that out 20 million times.
Right. Understood. Understandably.
So, yeah, as we're going through this, I also want to teach people the parts of a complaint. So you'll get down to the parties, line 22. They tell you who the plaintiff is. It's the Department of Fair Employment and Housing.
Hold up. You skipped. Okay, so specifically the violations pled herein include claims for sexual discrimination in terms and conditions of employment, including compensation, assignment, promotion, constructive discharge, termination, unlawful sexual harassment, retaliation, failure to prevent discrimination, harassment, and retaliation, and unequal pay.
Yes.
That's a lot.
That is coming later in more detail. Sorry, I didn't mean to gloss over that, but we're getting to that.
I'm just saying, like, that's a lot. They are bringing a lot against Blizzard.
Yeah.
So,
oh yeah.
The parties.
Go in there. You say that paragraph 9, the plaintiff, who they are, where they get their power from, the code sections, what their authority is.
Okay, so that's what this stuff is. It's just explaining who the Department of Fair Employment and Housing is, and then who the defendants are, which is Activision Blizzard. So that's what those...
Yeah. So you want to know why they're bringing this. If you go to page 6, line 3, the DFEH is charged with enforcing the Fair
Employment and Housing
Act, initiating and investigating complaints. As you go through, it investigates and prosecutes claims under the Labor Code 1197.5, which prohibits employers from paying employees of one sex less for substantially similar work. And remember, not exact work, substantially similar. Just because one person is coding in the animation department while the other person is coding in the accounting department, substantially similar. They're both coders.
Right.
You can't say one's harder than the other. Yeah.
At its discretion, they may bring a civil action in the name of the department on behalf of a group or class of persons adversely affected in a similar manner by an unlawful practice.
Which they've done here.
Yeah. And it may seek remedies to vindicate what it considers to be in the public interest in preventing discrimination. There it is. That is why they brought the lawsuit. Because it is part of the public interest. That's it. That's why. I was wondering why. Okay.
In paragraph 10, that starts at line 16, they identify the defendants. In this particular case, the defendant, Activision Blizzard. You find out that, hey, the headquarters are in California, but they incorporate in Delaware. Why did they incorporate in Delaware? Just as a side note, Delaware incorporates a lot of huge businesses because the corporate laws in Delaware are very favorable to those businesses. Now, you can incorporate anywhere in the U.S. and have your headquarters somewhere else. That's not illegal.
Well, we were kind of talking about this when we were discussing the NRA and their whole situation.
Right.
So you've got 1, 2, 3, 4 paragraphs devoted to explaining the different defendants.
Yes.
So you have Activision Blizzard Incorporated, Blizzard Entertainment Incorporated, then Activision Publishing Incorporated, and then Doe's 1 through 10.
Yes. All of them Delaware corporations operating in California.
Yeah. So because they operate in California, that is why, the headquarters are in California. They're based in California. Their employees are in California. So it falls under California jurisdiction, regardless of where they're incorporated.
Correct.
So moving on from that, that's all pretty. We all know who the defendants are. We don't need to go into that.
Now, if you go to line 17, where paragraph 14 starts, this is the legalese section that basically says they act as one company.
Okay.
So they are alter egos of each other. And if one of them is liable, they're all going to be liable.
Right, because they're all under essentially Activision Blizzard at this point.
Right.
Just like if Disney had one of its subsidiaries being sued, Disney would be responsible because Disney is the ultimate head of the
The end of line end of line 25. All of the acts and failures to act alleged herein were duly performed by and attributed to all defendants. So even if only Blizzard did the cube crawls, that's imputed to the other two companies as well, and they're all going to be liable for it.
Well, Activision essentially owns Blizzard. They should have stopped it. They're responsible for it.
Yes, even if they didn't, and I'll just say this as a devil's advocate, even if they didn't actually know, that cube crawls were going on. They're still liable for it.
They knew, though. There's no way they didn't.
Well, I will say, just as a devil's advocate, Blizzard's headquarters and campus is in Irvine, while Activision's is in Santa Monica. You're going to have to show, if you wanted to show direct knowledge.
You can't tell me that Mike Morhaime didn't talk to Activision heads as well. Okay. You can't.
No, he did. Do you think he said, "Oh, we had a cube crawl yesterday"?
I think if they're all buddies and it's a frat boy culture, yeah, they probably did. Oh, we had a cube crawl last week. I mean, you should have seen the girls, man. Yeah, absolutely. Absolutely, I do.
Okay, now, without this section, you would have to prove that.
Well, of course, but I'm just saying.
Now, with this section and being, alter egos of each other, you don't have to prove the direct knowledge.
Oh, I gotcha.
Yeah.
I see. That's the point of that being in there. Yeah. I see. Well, if you're cultivating a frat boy culture, yes, they're going to brag about it. People are going to know. Because that's what they do. So, continuing down,
you get some more legalese, starting at line 5, and this is page 8, by the way. Procedural history, jurisdiction, and venue. Venue is where the lawsuit is going to be heard.
Okay.
And in this case, County of Los Angeles is the proper venue because the headquarters of Activision Blizzard, Santa Monica, which is LA County.
Yeah. So it'll probably be heard at the Los Angeles courthouse, or
it could be in Santa Monica. Doesn't necessarily have to be in
case. I would actually like to sit in on the case. I don't know if it would be, but if it's a jury trial,
all cases are public.
Do you think we could?
The only time you've had secret trials is, my opinion, some of the people that got incarcerated in Guantanamo.
So I would like to find out when they have I'd like to go. I would like to go if we can, is what I'm saying.
Okay.
I would like to see this. I doubt that we can record, but we can take notes, right?
Yeah, you can't record without permission. You cannot take pictures without permission. That's why in the news you always see drawings.
Right, but we could take notes and stuff.
Oh yeah, you can take as many notes as you want.
I would like to try to go into that case when it starts. I'd like to go into that trial when it starts. Because 1, I've never been into a trial before. 2, this is something that I really would like to be a part of. I would really like to go to it. All right, we're on page 8, line 10.
10, right. This is where it's a procedural history of what's gone on in the case so far.
Mm-hmm.
And you find out that the director of the DFEH served a complaint for investigation on October 12th, 2018.
Okay, so this investigation's been going on since 2018.
Right. So is it surprising that people have left in droves since October 2018?
No.
No, of course not.
They're still responsible though, even though they're not working for the company. They left before shit hit the fan. Right. They left before shit hit the fan. And that's why you don't have the people that's over Blizzard anymore because
That's all about stock options.
Yeah, they either left of their own volition or they were asked to leave. I think it was a matter of they left on their own volition because they didn't want to lose their money.
Yeah. And you can see back then that the complaints consisted of discrimination based on sex, failing to hire, select, or employ persons because of their sex, as well as discrimination and compensation. You know, and that they failed to take reasonable steps to prevent it. And then you find out in the paragraph 18 on line 23, after more than 2 years of investigation, they issue a cause finding on June 24th. And in that finding, they found evidence that defendants discriminated against female employees, found that female employees were subject to sexual harassment, found that defendants failed to take all reasonable steps to prevent discrimination, harassment, or retaliation, and then that they committed violations of labor code section 1197.5 by paying female employees less than their male employees for substantially similar work. And a complaint will usually say things over and over again.
Right.
That's that's nothing we haven't said previously. But just the way a complaint is drafted.
Yeah.
This won't be the last time we say these things either.
Okay. So the next section, page 9, line 5, paragraph 19, it says they attempted to resolve this matter without litigation.
Yes. And I'm going to read this in its entirety.
Okay.
Prior to filing this civil action, the DFEH required all parties to participate in a mandatory dispute resolution in the department's internal dispute resolution division, free of charge to the parties, in an effort to resolve the dispute without litigation. So they were required to attend.
Okay.
Didn't charge them a damn thing to do this. And specifically, the DFEH invited defendants to participate in a mediation session with department's internal dispute resolution division on July 1st, July 2nd, and July 15th, 2021. But the parties were unable to resolve the administrative complaints.
Okay, what does that mean? They free of charge. What does all that mean?
A lot of times, a mediation, there's a charge.
Okay.
The mediator charges his fees. Sometimes you have to pay court reporters and everybody who's recording it or transcribing it. There's a lot of
so basically this
costs go into a mediation.
What you're saying is the state of California gave them an opportunity multiple times to fix this and come to a conclusion and move forward to do better, and they never took it.
Correct. Now, we don't know what the DFEH was asking of the defendants. That's not in here. But the defendants had got to know that they're going to be nailed.
Right.
So once again, I don't understand why they didn't settle then.
Well, the next, it says, in the case of failure to eliminate an unlawful practice through conference, conciliation, mediation, or persuasion, or in advance thereof if circumstances warrant, the DFEH may bring a civil action in the name of the department in state and federal courts.
Which is what they did.
Which is basically saying because they gave them an opportunity, they now get to do this.
Right. And so in the line 15, paragraph 21, you'll see it says all administrative procedures precedent to this institution of the lawsuit have been fulfilled. Got to put that in there. Otherwise, the defense are going to say, you didn't follow administrative procedures. And then that would become its own mess.
Oh, dear God.
And so by operation of a signed agreement between the parties, the department's deadline to file this complaint was July 21st, 2021, 6 days after the last mediation session. And you'll see that it was filed July 20th.
Yeah. The amount of damages sought by this complaint exceeds the minimum jurisdictional limits of this court. What does that mean?
Yes. This is a Superior Court unlimited jurisdiction case. So I will break down what the 3 different minimum jurisdictional limits are.
Okay.
Small claims court, as I recall, is now 10,000 or less.
Okay.
Then you have limited complaints, which are valued between 10 and 25,000. And then you have the unlimited jurisdictional Superior Court complaints, which are $25,000 or more.
Gotcha.
And what this is saying is the amount of damages sought exceeds the $25,000.
Gotcha. Oh, okay. So basically, it's letting us know that this is not a small claims. This is big.
Right. It's not a small claims. It's not a limited, small case. This is a huge case.
Yeah. So next.
You got the government enforcement action allegations.
We're only at page 9. We're just now at page 9, and we are an hour into this. Just FYI.
Well, we're going to start getting into a lot of duplicity or duplicative things.
Duplicate.
For example, So, for example, paragraph 24 here on line 22 says they're bringing this enforcement action for group relief on behalf of.
Well, they've already said
public.
that. Yeah.
Right.
Okay.
And this probably isn't the last time you'll see that.
Right.
So these paragraphs that are coming, 24, 25, 26, have all been addressed earlier.
Yeah.
And so we will go down to page 11.
Okay, so all of that was just reiterating what's already been stated.
Yes.
Okay. Oh, 11, factual allegations.
Yeah. And
okay.
I will go back to line 29 of page 10.
Okay.
But you wanted to know why this was not a class action.
Oh, you mean line 20, paragraph 29?
Yes, sorry. Yes.
Like there's no line 29.
And you'll see that enforcement actions are designed to protect the public and not benefit private parties. And in such cases, the seeking of monetary remedies was not the primary object of the suit, as it is in most private class actions.
Ah.
Okay. So really what they want in this is the injunctive relief and civil penalties. Money for the group is going to be secondary. And that is why this action...
It's not a class action.
On line 27 is not subject to class certification, and nothing requires it to be filed as a class action. And thus on page 3, or page 11, line 3, the DFEH is exempt from class action certification.
Okay, so this is filed on behalf of... Okay, so they're wanting to get money for the group, but their primary function in this case is to deal with the criminal activity, essentially.
Well, there's
the
illegal activity.
There you go. The illegal activity. Yeah.
Yeah. Criminal is specifically penal code violations,
My bad. The illegal activity is what they're after, is what they're dealing with. They want to take care of the illegal activity. And so that's why it's not a class action. Okay.
Right.
All right.
Okay. Now, you see on line 30, on line 5, that the DFEH...
Paragraph 30, line 5. You said line 30, line 5.
Oh, paragraph 30, line 5. The DFEH incorporates and realleges all previous allegations as if fully set forth therein. So in order you got to put that in there so you don't have to restate everything that you've already said. And you will see this numerous times. For each cause of action in the complaint, you will see this line. If you don't have this line...
and realleges all previous allegations.
Yeah.
Okay.
If you don't have that in there, you would have to put copies of it on every single class action.
Holy crap.
This would turn into, a 50 or 60 page thing. So the first allegation here is sex discrimination in pay, in assignments, in promotions, and terminations, and constructive discharge.
So their primary thing is the discrimination. Yeah.
Yes.
So, okay.
And once again, 32, practices began at higher when women were offered lower compensation and less lucrative job assignments, paid significantly less in starting pay than the male counterparts, and this pattern and practice and violations continuing.
They go into detail and talk about it for... Holy smokes. That's several pages of this. Let's just kind of hit the highlights. And there's 4 pages specifically on this discrimination?
Yeah. 33, we've already dealt with. 34, women were afforded less stock and incentive pay. They were assigned into lower levels.
Overwhelming.
Yeah, overwhelmingly assigned into lower grades and levels without stock and incentive pay. So the men would get stock options, the women would not.
Yeah.
And if the female employees did receive any kind of stock, they got less than the men.
They were steered into lower levels of the hierarchy and often had to work harder and longer to earn equal promotion than their male counterparts.
Yeah, and they give an example. A female employee working at Blizzard Entertainment was assigned to a lower level role, denied equal pay, and subsequently sought a promotion because she had been carrying out duties exceeding her job description. She was repeatedly told it was not her turn and others deserved a promotion ahead of her. Ultimately, the employee was promoted after 3 years, while her male counterpart was promoted within a year of his hire, despite having started several months after her.
Her male counterpart was also assigned leadership responsibilities, which she was not afforded. Responsibilities which furthered the male employee's ability to get promoted.
Yes.
Line 36, page 12, or paragraph 36, page 12. In another example, a female employee who worked at Blizzard Entertainment was assigned to a lower level, denied equal pay, and passed over for a promotion despite multiple factors that suggested she earned it. 1, highly rated performance reviews. 2, she generated significantly more revenue in her marketing campaign than her male counterpart. And 3, she ran almost twice as many campaigns as her male counterpart. Despite her accomplishment, her male counterpart was invited to have monthly or weekly one-on-one meetings with the vice president. She was not afforded these same opportunities and, unsurprisingly, was passed over for a promotion in favor of her male counterparts.
Right. And this would have been part of the evidence in the mediation. You know, how they just ignored this kind of is, you know.
I love 37. Similarly, other female employees at Blizzard Entertainment were assigned to lower level roles, denied equal pay, and further delayed or passed over for promotions in favor of male counterparts who lacked the same experience or qualifications, but who were friends with the male head of the unit. A newly promoted male supervisor delegated his responsibilities to his now female subordinates in favor of playing Call of Duty. Other male supervisors would refuse to communicate with female employees, going to their male counterparts for information.
Yes.
And it just, each paragraph are examples of female employees being disregarded for promotions.
Paragraph 38 is the same thing happening in Activision Publishing.
Mm-hmm. Showing that the women were doing substantially more work than the men, but the men continued to get promoted.
Yes.
And paid more.
Yeah. And then paragraph 39, you see that female employees were not promoted because of defendants' discriminatory practices against pregnant female employees.
Yep.
And they give an example of a female employee working on one game team had assumed some responsibility of a manager, but when she asked her supervisor about
her
being
male
supervisor, well, yeah,
about being paid fairly for the work she was actually doing and promoted into that position, the manager commented that they could not risk promoting her as she might get pregnant and like being a mom too much. Excuse me?
That is not uncommon.
In general, female employees were further treated negatively due to their pregnancies. Supervisors ignored medical restrictions given to female employees and gave them negative evaluations while they were out on maternity leave. This is not exclusive to Activision Blizzard. Let me repeat that. This is not exclusive to Activision Blizzard. Women are treated like this across the board. This is not exclusive to Activision Blizzard.
Furthermore, female employees reported they were criticized for leaving to pick up their children from daycare while their male counterparts were playing video games, and female employees were kicked out of lactation rooms so employees could use the room for meetings.
That is so illegal. Illegal. All of it is illegal, but that.
You can't tell me that Activision Blizzard didn't make enough money or their campuses were not large enough that there were other rooms.
There were other rooms.
Yeah.
There were other rooms. Line 40. We're on page 13, paragraph 40, line 7. Women of color were particularly vulnerable targets of defendants' discriminatory practices. An African-American employee noted that it took her 2 years to be made into a permanent employee, while men hired after her were made permanent employees. She also was micromanaged such that her male coworkers were known to be playing video games without any intervention by her supervisor, but her supervisor would call and check on her if she took a break to go on a walk. Other African-American employees who worked on information technology was similarly micromanaged by her manager, unlike the men on her team. When she requested time off of her work, her manager made her write a 1-page summary of how she would spend that time off of work when no one else had to do any write-up. I'm sorry, are we in 5th grade? Excuse me? Why are we writing a summer? It doesn't matter what I do with my time off. You are not paying me for that time off. You are not there. No, it doesn't matter. She can do whatever the heck she wants with her time off. That's her time off. The male supervisor also criticized her body language despite male counterparts slouching in meetings, and she was scolded for asking for assistance while others could get help on similar tasks without the same criticism. These experiences led female employees to leave their employment with the defendants.
Constructive discharge.
Yes.
41, we pretty much...
It just goes into the gender pay gap.
Yep. 42, line 23, when they complained to, when the women complained to the human resources about lack of equal opportunity and other things, their complaints fell on deaf ears or were met with an empty promise to investigate. And despite having the defendants retain Paul Hastings and the Miller Law Group to allegedly provide analysis related to compensation data, defendants failed to take effective and reasonable steps to prevent pay discrimination. So they knew from their own internal investigation that there was this pay disparity, and they didn't care.
They knew that. That's the thing that like really frustrates me about this whole case. Like this is not news. I know this is a thing, and I know like this is something obviously because I'm actively working to try and change this kind of stuff. But the fact that their own internal investigation showed this stuff and they still didn't do it says a lot about the type of company they are.
They knew it to begin with. They were kind of hoping, I bet, my opinion, that this investigation is going to show that it's not that bad.
It's not that bad. Right. No, it is. And yet they didn't do anything. They didn't care to do anything. And that's the problem.
43 goes to show that they accepted less compensation.
It just continues to talk about
the compensation. They were promised that they would get compensation in other ways, and they never did. Excuse me. 44 on line 9. They terminated female employees more quickly than their male counterparts. And then 45 is a summation.
Yeah.
Of that.
So on line 15, this is sexual harassment.
Yes. And it starts on line
16, paragraph 46.
Yeah.
Female employees almost universally confirmed that working for the defendants was akin to working in a frat house, which invariably involved male employees drinking and subjecting female employees to sexual harassment with no repercussion. And it goes into depth about the cube crawls, how
and the frat boy culture.
Male employees would proudly come into work hungover. They would play video games during work, engage in banter about their sexual encounters, talk openly about female bodies, make numerous jokes about rape.
Here's some examples because they've gone. This is like the third time they've said this.
Yeah,
a female employee noted that random male employees would approach her on defendant's worksite and comment on her breasts. Female employees working for the World of Warcraft team noted that male employees and supervisors would hit on them, make derogatory comments about rape, and otherwise engage in demeaning behavior. This behavior was known to supervisors and indeed encouraged by them, including a male supervisor openly encouraging a male subordinate to buy a prostitute to cure his bad mood. Yeah. Okay.
This
Page
next one. Woo-hoo-hoo!
Yeah.
Woo! This next one. Page 15, line 1, paragraph 47. Names a worker in Blizzard. I'll let Ron do this one.
Yeah. A blatant example of the defendant's refusal to deal with harasser because of his seniority position names Alex Afrasiabi, the former senior creative director of World of Warcraft at Blizzard Entertainment, was permitted to engage in blatant sexual harassment with little to no repercussions. During a company event, an annual convention called BlizzCon, which I believe started in 2008 and is still going on.
Yeah, they did it digitally this year at the beginning of the year, but yeah.
Afrasiabi would hit on female employees, telling them he wanted to marry them, attempting to kiss them, and putting his arms around them. This was in plain view of other male employees, including supervisors who had to intervene and pull him off female employees. Afrasiabi was so known to engage in harassment of females that his suite was nicknamed, and they put it in as the Crosby Suite, after alleged rapist Bill Crosby. That is a typo. It's Bill Cosby.
Just realized that.
Yeah.
I'm not laughing at the fact that they called it the Cosby Suite. I'm laughing at the fact that somebody had a typo. And now it will always be there because this is a legally binding document and they always have to misspell this now.
If I am not mistaken, Alex Afrasiabi was handpicked by Chris Metzen for that position.
Well, all I have to say about that is that's disgusting. And that just
And so you have him calling females derogatory names at the company events. And his conduct was known to Blizzard Entertainment's executives who took no effective remedial measures.
You have somebody that is a literal rapist. You joke about it and you do nothing. You continue to allow this person to work and be around people and hurt people.
Yep.
Because he has a penis. Because he has a dick.
Okay.
It's disgusting.
We're getting into some of the more meaty sections of the complaint now.
I'm aware of that.
I know you're aware of that.
Just saying.
J. Allen Brack, the president of Blizzard Entertainment, allegedly had multiple conversations with him, but gave him a slap on the wrist, verbal counseling. And that's all he did. And then this president puts out a statement later saying how we need to listen to the female employees and what they've gone through.
It's so that you need to fire them. You need to fire this guy. You need to fire the problem.
So subsequently, after all of these conversations, he still continued to make unwanted advances towards female employees, including grabbing a female employee's hand and inviting her to his hotel room and groping another woman. So I can tell you what I think of J. Allen Brack and Alex Afrasiabi.
And the final one, which is the most heartbreaking one.
Yeah, as paragraph 48, it starts on line 17, where we touched on it before in the introduction that a woman committed suicide. The defendants allowed to fester harassment in the offices that a female employee committed suicide while on a company trip due to a sexual relationship that she had been having with her male supervisor. Now, I will say it does not say consensual or non-consensual. The male supervisor was found by police to have brought a butt plug and lubricant on this business trip. Another employee confirmed that the deceased female employee may have been suffering from other sexual harassment at work prior to her death. I am thinking that this was not a consensual sexual relationship.
That is something we are not aware of, but regardless,
Specifically,
why are you bringing a butt plug on a business trip? I mean,
well, as the devil's advocate, some people like butt play.
Well, what I mean is, why are you bringing sex toys on a business trip? It's a business trip.
Well, it is a business trip. But if you're having a consensual sexual relationship with a coworker,
she committed suicide, though. That wasn't consensual.
Right. And it's a supervisor. As my grandma would say, you don't dip your pen in the company ink. He's in a position of power over her.
Coercion is rape.
Okay. And specifically, at a holiday party before her death, male coworkers were alleged to be passing around a picture of her vagina. You know, there's only one place that picture came from. That was that male supervisor. So there you go. I'm surprised that there hasn't been a lawsuit for a wrongful death, personally. And now I don't know that a statute of limitations for that hasn't passed. Line 24. The retaliation and defendants' failure to prevent discrimination, harassment, and retaliation. Paragraph 49 starts at line 26, where you find out that the defendant's former chief tech officer was observed by employees groping inebriated female employees at company events and was known for making hiring decisions based on female applicants' looks.
Oh, Jesus Christ.
An employee complained, once again, to Blizzard president J. Allen Barak that employees were leaving due to sexual harassment and sexism, and specifically noted that women on the BattleNet team were subject to disparaging comments. The environment was akin to a frat house, and that women who were not huge gamers or core gamers and not into the party scene were excluded and treated outsiders. And of course, he did nothing.
You're not a big gamer, so you don't count. You're not a real gamer. Okay, I play games. I'm a gamer. Even if it's a casual thing, I still play. And, you know, not everybody who works for game companies is going to want to play games. Some people just enjoy coding and just enjoy creating this stuff. It doesn't matter. They're your employees. They're your coworkers. They're your colleagues. Who cares?
Right. And then you've got, paragraph 50, which starts on line 7. They go to HR. They've been groped. HR doesn't do anything in response.
And this is just reiterating in detail how much lack of trust that was had with HR. Like, HR really did nothing. And honestly, if HR is there for the company, you would think HR would have done something, right? But they didn't. Like, HR kind of screwed them. They screwed the pooch on this.
HR is not protecting anybody in this. Not protecting the corporation, not protecting the employees.
No, HR really messed up with this one. Like, this is the case where HR should have done their job and removed the problem people. But it sounds to me like HR was also doing some of the harassment.
I suspect that these complaints had been ongoing since the beginning of Blizzard, and nothing has happened to them in 10 to 20 years. So they weren't going to do shit. My opinion. And now they're reaping the whirlwind.
Yeah.
The next sections just reiterate what we've gone on before as far as retaliation goes. And finally, we get to the first cause of action.
What is that?
A cause of action is the specific allegation of what they did wrong.
Okay. So this is page 16 at the very bottom, line 24.
Yes. Employment discrimination because of sex - compensation. And it gives the government code that they violated. Government code section 12940, subdivision A. And here we have paragraph 53, line 26. My favorite portion where it says DFEH incorporates and realleges all previous allegations as if fully set forth herein.
We don't have to repeat those, babe.
Okay, that's going to be the last one I say.
Okay, thank you. Okay.
And here, paragraph 54 just tells you what the government code says, and that it's unlawful employment practice for an employer to, quote, discriminate against the person in compensation or in terms, conditions, or privileges of employment because of that person's sex. And so they would have to, in order to win on this cause of action, they have to show that there's discrimination in pay or in benefits such as stock or in hours worked or in being able to take breaks or leave early. And it seems like you're going to have substantial proof of that.
And it just continues going with all of these. You've got the first, you have 55, 56, 57, 58, 15 or 55 through 57 are just reiterating what we've already said, that and reiterating that they are compensating them. They start them at a lower wage, they fire them at a faster rate. But I do like 58. It says, as a result of defendants' unlawful employment practices, female employees suffered and continue to suffer harm, including but not limited to lost earnings, lost benefits, lost future employment opportunities, and other financial loss, as well as non-economic damages. And 59, this is beautiful. Defendants' actions demonstrate that they will continue to engage in the pattern or practice of unlawful employment discrimination and unlawful disparate impact discrimination prohibited by FEHA unless they are enjoined pursuant to the police power granted by government code sections, blah, 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 from failing or refusing to comply with the mandates, et cetera, et cetera. So that's it. Basically, from what I'm understanding, let me know if I'm right or wrong. That basically says, without us stepping in, based on the patterns that this company has shown, they would continue with these illegal practices if we did not step in.
Correct.
And that is why they stepped in. Defendants' actions are willful, malicious, fraudulent. Okay, I'm sorry.
Okay. Paragraph 60 is most important because this kind of conduct gets triple damages.
Oh,
also called
what they're stating in 60? Okay.
Yes. Punitive damages. In order to get punitive damages, you have to have willful and malicious conduct.
Okay. So 60 is stating that their actions were willful, malicious, fraudulent, and oppressive, and were committed with the wrongful intent to injure female employees in conscious disregard of their rights.
Right. So you can't have willful and malicious if you just were passive or negligent.
Mm-mm.
And that's why they have the word intent in there.
This wasn't passive. Not
Right.
not at the level at which they did this. It's not one or two. It is all of the female employees. And the second cause of action on page 18 is employment discrimination because of sex promotion. So then they go into
sex dash promotion.
Yeah, sex dash promotion. So then they go into how they intentionally discriminated against women on advancement opportunities. And there's 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11 paragraphs on this. Yes. And a lot of it is saying the same shit that was there before. Defendants' actions demonstrate they will continue to engage in this pattern. They were willful, malicious, fraudulent. So it's a lot of the same stuff that was said in the last one. And then third cause of action be based off of sex dash termination, which is reiterating what we've already said, what we've already gone into detail. This is just more paragraphs of the thing. Same thing, willful, malicious, fraudulent.
Of wrongful intent.
Yeah. Fourth cause of action, sex dash constructive discharge. Again, same
discrimination
thing.
Because of sex.
Yeah.
Dash constructive discharge.
I'm sorry. Discrimination because of sex dash constructive discharge. For example, in denying women promotions, assignments, and a compensation in comparison to their male counterparts, and subjecting them to sexual harassment and a hostile work environment, defendants effectively forced female employees to leave their employment with defendants. Female employees accepted less compensation than they were making in their prior employment or offered by other companies to work with defendants, as defendants promised to make up the pay differential with future promotions or increased compensation. Given defendants' promises, female employees came to work for defendants only to realize that the promises were empty and watch as male comparators were promoted more quickly and offered more compensation. So basically, they're alleging that they would give these grandiose things to them in the interviews and say, here, come here, we'll pay you more, we'll give you promotions, blah, blah, blah. And then they never did it.
Right.
And then the fifth cause of action, sorry, we're like way over time. So I'm trying to, we've gone through a lot of this detail. Like the last little bit of this is just like, yeah. So the fifth cause of action, employment discrimination because of sex dash harassment. And this is where they go into the sexual harassment.
Creating the hostile work environment.
Yes.
Important word, hostile work environment.
They state, page 22, line 1, paragraph 98, harassment was perpetuated by defendants' supervisors and or they knew or should have known of the conduct and failed to take immediate and appropriate corrective action.
Yes.
I think that's really important to note that is in the document. And again, malicious, willful, malicious, fraudulent, and oppressive. And unless they are enjoined, they will continue based off of patterns. And their sixth cause of action is retaliation.
Yes. Which, they weren't given Oh my God. I'm starting to lose my
Yeah,
mind.
it's getting late. We've been on
You know,
this a while.
the adverse employment actions, denial of professional opportunities, negative performance reviews, transfers to less favorable units, things like that.
Yeah.
They were forced to be late. They were laid off in retaliation.
Yeah.
Yeah, things we have said before.
Seventh cause of action, failure to prevent discrimination and harassment on behalf of group.
Right.
So, this is saying, I get,
the government code section states an unlawful employment practice for employers to, quote, fail to take all reasonable steps necessary to prevent discrimination and harassment from occurring. As we have talked about previously, they took no
action. They slapped them on the wrist and said, don't do that. Because that's really going to stop people.
Right. And then the eighth cause of action, which is on page 25, line 1, failure to prevent discrimination and harassment on behalf of the DFEH.
Oh, what? Hold on, what's that?
Yeah.
Okay.
This is a different code section, but requires employers to take all reasonable steps necessary to prevent discrimination and sexual harassment from occurring. So the seventh cause of action is going to ask for some kind of compensation for that. This cause of action, because it's on behalf of the DFEH, is going to be asking for some kind of civil penalty or fine.
Oh, I have a question. Could some people go to jail because of this?
No.
Oh, you don't. So
not from this complaint.
Not from this particular lawsuit.
But if you find that people were forced to have sex, they were groped, there
could be another lawsuit.
Could be criminal penalty.
Wow. So somebody, okay. Oh, that's the difference between illegal and criminal. Okay. They have to violate. Okay, I get what you say. I get what you mean when you say they have to violate the penal code. Okay. It seems to me like they were kind of violating the penal code with some of this stuff, but.
Yeah, I mean, you just can't go up to a woman and grab their genitalia,
Grab them by the pussy.
Yeah.
Jesus Christ. So anyway.
Ninth cause of action, unequal pay.
Yes. Ninth cause of action is unequal pay.
Once again, similar work, not exact work, similar work.
10th cause of action, waiver of rights, forums or procedures, and release of claims. I'm not sure what that is.
Right. The government code section here defines an unlawful practice, and a person shall not, as a condition of employment, continued employment, or the receipt of any employment-related benefit, require any applicant for employment or employee to waive any right, form, or procedure for a violation of any provision of the Fair Employment and Housing Act. So you can't give up your rights. You can't say, we'll employ you, but you have to do this.
Oh, and they're saying that's what they did?
Yeah.
What?
Yeah. Based on paragraph 141, line 9 on page 27, based on information and belief, DFEH alleges the defendants required female employees to waive rights, forms, and or procedures as a condition of employment, continued employment, or the receipt of any employment-related benefit, including but not limited to adjustments, payments, or severance pay.
Okay. So, in line 17, paragraph 143, based on information and belief, the DFEH alleges the defendants' female employees were required to sign a release of claims and or rights in exchange for underpayment of compensation or an adjustment bonus, raise or payment, and or other employee-related benefit in violation of Government Code Section 12964.5. By engaging in the conduct that set forth above, defendants acted in conscious disregard of the rights or safety of others and acted in an oppressive, fraudulent, or malicious manner in violation of California Civil Code Section 3294. Whoa!
Yeah. Basically, you get this raise, but you're going to waive any kind of litigation or lawsuit claims against us.
What?
Yeah, that's...
They have to have something. They have something then that we're... What?
Yeah.
That's what? Okay. What?
And
sorry.
then
I'm sorry. Like, what?
Page 28, line 7.
Jesus Christ. Okay.
This is the end of every complaint that gets filed. The
Pray
prayer
for
for
relief. Okay.
This is what they want.
Okay.
Okay. Number 1, compensatory and punitive damages. So,
yeah.
You know, we know what that is.
Number 2.
Unpaid wage to go ahead and ask.
Oh, I was just saying, I was trying to push you to continue.
Okay.
2.
Number 2, unpaid wages, liquidated damages, and other remedies and penalties available under the Equal Pay Act, which means
back pay.
Everything that they were denied, back pay. Yeah.
Well, that one guy had $154 million last year. He can afford that. Okay. He can afford that.
Oh, yeah.
Just saying. They can afford it. Okay, number 3.
Injunctive relief. Stop doing what you're doing, and we're going to monitor you.
Number 4.
Declaratory relief.
So they have to come out and say it.
Yep.
Number 5.
Equitable relief. Limited, not limited to reinstatement and or front pay, pay adjustments, back pay, lost wages, benefits, in an amount to be proven at trial.
Oh, so I guess at trial they will decide, okay, this is what your coders should start at. This is where I guess they'll go over that in trial.
Hey, if the male coders started at 70 and your female coders started at 50, it looks like all your coders are going to be paid $70K from now on.
Right. Okay.
Okay. Now you got 6, prejudgment interest as required by law.
What does that mean?
That means everything that's been all the back stuff that you're looking for reinstatement is going to have interest attached to it.
Okay.
So,
Jesus.
Yeah, that's big because, 3 years of interest on that stuff, if not longer.
Right.
7, the attorney's fees and costs, which, can be very substantial, even with government attorneys. And 8, standard, other relief the court deems to be just and proper.
So, and then the final page just says demand for jury trial. Plaintiff hereby demands a trial by jury on claims. So with that being said, we're at the end of this, and I know that a lot of people. So Blizzard officially what? Oh, sorry. Hold on. Okay. Had a little hiccup here. Blizzard officially came out and you have you had your internal email from Brack and all of that stuff. I have it all linked in there, and it wasn't good. It wasn't good. Like, they were essentially gaslighting and denying everything. And they're going to do that because this is going to trial. They're not going to come out and they're not going to say, yes, we did it, we're guilty, right? They're not going to do that. They don't want to do that because they're going to trial. They have to deny it. You have to if they have to make a statement, it's got to be a denial statement, is what I'm saying. Like, they're not. So I know a lot of people are upset and they're like, these comments or, these statements that have come out are such bullcrap. And it is. And it's going to be. It's going to be, because if they were to admit it, that could be used against them in the trial.
Yes, it could.
So they're not,
which is why
going to.
If I was their counsel, I would have had them settle this thing a long time ago.
Right. Because this could potentially be really bad for them. I mean, it's bad already, but I mean, like,
well, it should be bad for them.
Well, yes, but I mean, they could go under. Bad is what I'm saying, because that's a lot of money that they weren't paying their female employees. And a lot of I know that a lot of people have come forward and talked about their, they've done twitlongers and stuff like that. And if you can handle it, I recommend reading their statements and what they have to say about it. Because it's
Now, I'm going to give my opinion before we're out of time.
Yeah.
This is an environment that just didn't pop up out of the blue. This is the kind of environment that has always been.
Mm-hmm.
So people have their people that they want to defend because they were favorites. Those people knew about it.
Yeah.
And condoned it.
Complacency.
And didn't do anything about it.
Complacency is just as bad.
And they're making statements now to give lip service to what happened is so hypocritical and beyond the pale.
Yeah.
I wish they just didn't say a damn thing.
Yeah.
But
now
I have, Blizzards are my game. Warcraft is my game, and
it's tainted.
I have lost. It doesn't surprise me. It has really disappointed me. And with respect to a lot of the people, I have lost any kind of respect for them. There's a mass exodus out of Blizzard by some of the original founders. And I can't help but think they knew this was coming and they got out when their stock options were high.
Yeah.
And they didn't have to be part of any kind of investigation.
They're still part of the investigation because they were there when it was happening.
Yeah. I'm sure they're
not free. And they're not free. They better not be.
People are still going to say, well, you probably didn't know about it. He knew about it. I don't care who it was. In my opinion, they knew about it.
This is why you cannot.
Warheim, Metzen, the one guy in charge of Overwatch, I forget what his name was.
Kaplan.
They all knew it.
Yeah.
And they got out.
This is why you can't be complacent. You have to be active in stopping this kind of stuff. You can't just stand there and watch it. People were hurt. A woman died. I attempted suicide 5 years ago in November because of someone involved in the Blizzard community. Because it's not only do they foster it in the industry, they foster it outside of the industry as well. The gaming community is a negative community towards women. And I have talked about my situation and the coercion and the vulnerability that we went through ourselves. I was on a podcast last year based off of it. This isn't new. And that's the thing that I need people have to understand. This is not new. It's not exclusive. It is everywhere. And you have to listen to the victims. You have to stop putting them aside and just saying that's just how it is, because it shouldn't be just how it is. I will say, though, for those of you who are giving people a hard time, who are continuing to play Blizzard games, it's not black and white. You can still enjoy the art, but not enjoy the artist. What Blizzard has done and what has come out is wrong. But every other AAA gaming developer is the same way. So this is the start for us as a community to make the change. This is where we pivot and we make it better for marginalized communities. This is how we make it better. We bring this stuff forward. We talk about this stuff. We hold these people accountable, and we stop allowing them to have Cosby suites and cube crawls and groping, and we have to stop it. And with that,
yeah, I can't add to that. You said it well.
I just want to say thank you so much for listening to Learning the Law podcast. If you like this podcast and want to hear more, don't forget to like, subscribe, follow, and share in all your favorite places. You can find it hosted live on Twitch at twitch.tv/PhoenixNymphy when we're not having technical difficulties. And use the hashtag Learning the Law on social media to follow in those places. You can find Ron on Twitter at Necrokijo, that's NECROKIJO, and me at Phoenix Nymphy. If you have any questions about today's podcast, please, or any other thing about the law, please tweet, comment, or email us at twolazydogsmedia@gmail.com. This has been a Two Lazy Dogs Productions, and to all of the victims and all of the survivors, we stand with you, we support you, and remember that you are loved and you are so, so worthy. Have a wonderful night, y'all.